Hello and welcome to Video 1, Overview of the Guardianship Process. We'll start by answering some basic questions. What is a guardianship? Well, a guardianship is a legal action brought to protect a minor child or an adult who lacks the mental ability to run their own affairs. Obtaining a guardianship for a minor child is a very different process than obtaining a guardianship for an adult. This video series only concerns the process to obtain a guardianship for a minor child in Idaho. Why would someone need a guardianship over a child? A guardianship provides a person with the legal authority to make important decisions for a child, such as enrolling them in school, taking them to the doctor, or protecting them from abusive or neglectful parents. Minor guardianships can be filed by any person interested in the welfare of the child, but are most often filed by a child's grandparent or close relative when the child's parents are in jail, addicted to drugs, physically abusive, have passed away, or have other problems that keep them from properly caring for their child. What are a guardian's responsibilities? Guardians have most of the authority and responsibility over a minor child that a parent of the child would have. This includes making sure the minor child is provided with things such as food, shelter, clothing, health care, and education. Guardians may also handle minimal finances for the child. If the child has more significant income or assets, the court would need to appoint a conservator to handle the child's finances. Additional responsibilities include filing a report every year to update the court on the status of the child. For more information about these reporting requirements, see Video 6 from this series. How do you start a guardianship case? If at all possible, we recommend filing a guardianship case with the help of an attorney experienced in these kinds of cases. Like any other legal case, a guardianship can be complex and confusing. Having professional help can make the process much easier. If you decide to file the guardianship case without an attorney, you can download a free packet of instructions and the legal forms you will typically need from the Court Assistance Office website, courtselfhelp.idaho.gov. You can also obtain the packet for free or a minimal charge from the Court Assistance Office located at your local county courthouse. The case is generally filed at the courthouse in the county where the child lives. While you will need to file multiple documents, the document that starts the case is called a petition. It tells the court who you want a guardianship over, why you think the guardianship is necessary, and other important facts. The person filing the petition is called the petitioner. Before the court holds a hearing, it is the petitioner's job to ensure that every person who has an interest in the case receive advance notice of the hearing, typically at least 14 days before the hearing is held. Notice requirements are very specific, and if you don't follow them correctly, the judge will delay your case. For information about the specific notice requirements, see Video 2 from this series. What happens after you file a guardianship petition? After a petition is filed and notice of the hearing is sent to all necessary persons, many cases proceed as follows. A guardian ad litem, or GAL, may be appointed by the court to represent the best interests of the child. This is typically an attorney who appears in court on behalf of the child. The child's estate pays for the guardian ad litem, but if the estate doesn't have enough assets, the petitioner should be prepared to pay. Next, a hearing is required before a guardian will be appointed. At that hearing, the petitioner will testify about why a guardian is needed and the plans for the child's future care. Any interested person can appear at the hearing and provide information about the guardianship. If the judge decides the guardianship is appropriate, he or she will issue letters of guardianship. These letters are a court order that the guardian can share with doctors, schools, law enforcement, and others to show that the guardian can make decisions for the child. What does the petitioner have to show the court in order to obtain a guardianship? The law does not allow guardianships to be granted in every situation. For a petitioner to be granted a guardianship, they must convince the court that certain requirements have been met. The petitioner must show that either the rights of the child's parents have been terminated by a prior court order, or the child has been neglected, abused, abandoned, or the child's parents are unable to provide a stable home environment. In addition, the petitioner must convince the court that it is in the best interests of the minor child to appoint them as guardian.